Gus update, 29-mile-per-hour gusts as well into northern city and over into Canada, 22-mile-per-hour wind gusts. Well, very relaxing.
We're live.
Good evening, everyone, out in our virtual world and where you are in your personal space. We welcome you to today's Generational Wealth Series, being brought to you by the Baton Sigma Alumni Chapter and being partnered with the Southern University Law Center. We are here today to bring you a very important topic. It is called estate planning. Are you ready? I am Shy Joseph Franklin, the president of Baton Sigma Alumni Chapter, where we have over 300 members who come to you in the community to bring you a wealth of programs. And one of them is economic development, which brings these conversations to you. We're coming into your space to be able to give you some valuable information. So we hope that you get a piece of paper and pencil and get into a comfortable position, because the Southern University Law Center employees, students, faculty, and staff, along with our members, have put together a great presentation for you today. Thank you for joining us. And at this time, I'm going to ask that we pause for a minute for a moment of silent meditation before we move forward into this program to receive this information. So I ask that you bow your heads at this time. Amen. And with that, we will turn it over to one of the chairs of our economic development team and committee, Ms. Frances Smith. Ms. Smith, you can unmute yourself at this time. Thank you.
Good evening, and I do apologize that I'm not able to be seen, but I'm having some difficulty with my camera and my computer. So I'm going to be coming to you with voice only. So please forgive me. One of the things that I'd like to tell you is that April is Financial Literacy Month worldwide, and in our chapter and for Deltas everywhere, it's Financial Fortitude Month. And we've been working very hard to bring you a series of very informative information that will assist us in trying to develop the things that we need to have in order to encourage generational wealth in our community. Tonight, our program is on estate planning, and we want you to be prepared. We ask our Saras and friends and families throughout our community to join us for this long-awaited community event. Baton Rouge Sigma is partnering with the Southern University Law Clinic that is a part of the Southern University Law School in order to bring this community activity. And it's a continuation of our 2021 and 2022 Generational Wealth Series. Our presenters tonight are going to have a broad spectrum of information for you dealing with estate planning, which including wills and living wills and successions, probate, and the things that you will need to know as it relates to these subjects and many more. So to get started, I would like to tell you that we are hoping that when you leave this session, you'll have the information that you need to know, one, what estate planning is and why it's important, and why you should begin early in this process in order to ensure that through the generations in your family, everything is put in place, and that one generation does not build a wealth community and then another generation comes and loses it because they don't know what to do and not following the whole spectrum of things that you need to do in order to protect your estates and what have you. Tonight, our presenters are professors in the with the clinical legal education program at Southern University Law Center, and they include Mr. Charlie Kane, who is a professor of clinical legal education, Mr. Christopher Fasulo, who is professor of clinical education, Ms. Alicia Grace Aubert, who is also a professor of clinical legal education, and Ms. Virginia Lestache, who is going to be our pilot on this flight tonight. She is the director of the law clinics at Southern University. We will have at the end of the presentations, and we ask that you hold your questions until the end, unless you want to drop your questions in the chat box. This session is designed to answer general questions regarding the information that we're sharing with you tonight. It is not, and I emphasize, not designed to give legal advice. The persons who have questions, you can send them. Again, we did not get any earlier, but if you have some, please post them as we go along in the chat box, and we will read them at the end at the appropriate time. Now, I would like to present to you Professor Virginia Lestache, who is going to be our guide for this evening, and Ms. Lestache will direct us further from here. Thank you.
And thank you, Francis, for that introduction. Let me just say, we have called this a progression of life plan. When we were sitting down discussing the topics we were going to discuss and where we wanted to go with this discussion, we thought about the fact that we're just talking about where life leads us and what we have to plan for. So we are referring this again to a progression of life plan. Next. So before I begin, I have to tell you about our clinical education program. As Ms. Smith said, I am the director of that program along with the professors who are in the program. Southern University Law Center has had a clinical legal education program since 1974. We started off in Baker City Court with a criminal clinic, and we have expanded since that time. The program itself has a dual purpose. The first is to educate our law students, to make them practice ready so that when they go out and practice, they can practice competently with confidence because they've had the training that we provide to them. The second dual purpose of our program is to provide service to low-income persons. We have a responsibility to the community and to those that are disadvantaged to make sure that we provide for them an access to the judicial system. So with the aid of our students, with the aid of supervising attorneys, I do believe we successfully achieve that in assisting persons within the East Baton Rouge Parish area and in some clinics outside of the East Baton Rouge Parish area in accessing the court system and other functions of the judicial system. Next. So just briefly, I want to say that this is a list of our professors that we have in our clinical program. And as you can see, we have a vast array of different types of clinics. We have 11 clinics in our program. The clinics focus on those needs that go unmet by persons who are disadvantaged. So we try to make ourselves available so that they realize there is an answer out there for them. There is a resource out there for them so that they can have their legal needs served. Next. So with that, I will begin with what we're here to discuss tonight. As I said, it's a progression of life plan. It is a plan that talks about getting your house in order. You can go next. This next slide, and I don't plan to read what's on the slides verbatim, but I read the list of information, I'm going to say, that we provide on this particular slide, and I thought it was important to read this, and I'll tell you why after I do. Life is full of unpredictability. At different phases of life, our needs change. There is an expected beginning and end, but the when and how remain unknown. There is always a need to plan for both the expected and unexpected life events. A prudent life plan responds to expected and unexpected life events to protect your family and your property at various stages. So what we have to think about is those things that are expected. We're expected to age. We're expected, some of us, to get ill. Some of us don't expect ourselves to get ill. But then the unexpected does develop throughout our life. And we have a responsibility to ourselves. We have a responsibility to those we love. We have an overall responsibility to ensure that our house is in order so that we can handle the expected and handle the unexpected. Next. You have a life plan. Do you have a backup plan? And basically, most of us think about the fact that we want to be in control of situations. We want to be in control of our life. Some of us believe that we are in control of our life, but we're not in control of everything expected and everything unexpected. But there are tools available for us that we can handle. I said people age. People age. You have property. You have family members that you have to protect, as well as yourself. It's not a topic that most of us want to sit down at the dinner table and discuss in terms of what will happen if we get ill, what will happen if we become incapacitated, what will happen in life. And it's just not a conversation that most of us have, but it's a conversation that's necessary, and it's a conversation that we should have. Next. The tools that we will be discussing tonight, insurance. Most of you are familiar with insurance. Insurance, whether that's to person or property, to protect those we love, to take care of those we love whenever we move on, or protect those that we love while we're here, liability insurance, or protect our property. Most of us have that form of protection, but there's a lot of other protections out there which we will be discussing tonight. We will be discussing estate planning. We will be discussing wills, living wills, advanced directives, successions, tax issues, disaster preparedness, powers of attorney, all those little tools. And I say little tools, and I don't mean that. All those major tools that we have that help us and aid us in controlling that journey that we take through life. Next. So I am going to turn it over at this point to Professor Alicia Hebert, who's going to talk about emergency preparedness.
Good afternoon. First, I'd like to thank you for having us here. I think this is a very important topic, and it's a timely topic considering some of the recent events that have occurred. One of the things that my clinic does is we discuss and plan for emergencies. And we try to provide information and resources to our communities about those things that are available to them, as well as try to assist in preparing for what we call the unexpected. Just to kind of piggyback off of what Professor Lestache was saying as we start to talk about emergency preparedness, we all know that we need insurance. We need insurance for various things. And I know that we often think about our insurance in terms of protecting our material belongings and our property. but we need to ensure that we're protecting our person and our identity in an effort to protect our finances. So one of the things that I want to talk about today as we talk about emergency preparedness is also protecting your identity, protecting your person, making sure that you are doing the things necessary to protect not only your personal information or identifying information, but also your finances. So emergency preparedness in Louisiana is no longer the unexpected. It's becoming commonplace. We have severe weather events. It looks like they're routine now. We've had several hurricanes that have impacted various parts of our state uh, and created a lot of havoc and devastation. Um, One of the things that we found over the years in our study of disaster relief assistance is that disastrous events are often followed by an uptick in criminal activity. And one of the reasons for that is that disasters leave people in necessitous circumstances, and then behavior changes. And sometimes that behavior actually causes people to do things that maybe they wouldn't ordinarily do, but definitely they prey upon the vulnerable and the weaker in our society. And so what we found is that a lot of our elderly population find themselves to become victims of identity theft and fraud following catastrophic events. And the main reason for this is because we have these instances where we're not prepared for the disaster that occurs. And so we are left trying to backpedal and get on our feet and get help and assistance. And we provide information about ourselves that we wouldn't normally provide. One of the most common things that I've seen occur following a disaster is persons forget to secure their identifying information. They lose their birth certificates. They lose their driver's license or some form of identification, and they become susceptible to phone calls from people who are offering assistance but are actually carrying out scams. And because you have inquired about assistance, you are more readily to give your vital information, such as your social security number, your date of birth, and the like, thinking that this is a response call to your request for assistance. And then the problems begin because the information that you provided to the source that you thought was attempting to assist you is being used to hurt you. And so we want to talk about taking those necessary steps as well as a part of this discussion. So you can lessen your chances of being criminally victimized by preparing an emergency preparedness kit. This will protect your personal identity and finances, as well as prepare you for the period following a catastrophic event. Well, how do I do that? The first thing is you have to have a plan. I think that's going to be the overriding theme tonight. You have to have a plan. So the first thing is designate a safe space for your important documents. If that's the beginning of your plan, then so be it. And then we can build from there. Oftentimes we're unable to get all of the things we need in situations when we have to move quickly because we don't know where they are. So the first step is to find a safe space for all of your important documents. Once you have that space, those documents should be secured in a fireproof or waterproof covering, for lack of a better word. I've seen several. There are now folders and boxes that are both waterproof and fireproof that can hold your things. And you can put all of these important documents there. Now, what you want to also ensure is that once you have this safe space and you have them in fireproof or waterproof coverings, that these are things that can be moved easily. So this is one of the reasons why we suggest, even if you have a safe for your items, that you still have them in some type of packaging where you can grab the packaging and go. It's very unlikely that you're going to be able to grab a safe and leave quickly. So you should always have these documents in something that's readily available to you. And easily attainable if you need to evacuate your premises quickly or move quickly. So that's the first step. The first step is a safe space. The second step is proper covering. And then you want to make sure that you have these things readily accessible. Another important aspect of this is making sure that you have duplicate copies of very important documents. They shouldn't be kept in your safe space. They should be kept in a separate location. In the event that all else fails and you're unable to get to your documents that you have in your safe space, you should have a separate location for retrieval at a later date if needed, or at another location if needed. I often tell clients, young and old, that you should always have a place outside of your home where you can keep things and know that they'll be safely maintained. That can be with a friend, that can be with a relative. But you want to make sure that they're secured and not susceptible to someone accessing them and making use of them outside of what you would want them to be used for. So maintaining your readily prepared kit is important. If your property is destroyed, you will still have that extra kit that you've packed to the side, and you will have access to the information that allows you to access information from third parties while preventing access by bad faith actors who are involved in scams or ploys to commit fraud. Now, one of the things that we've noticed is that oftentimes, and I'm sure anyone who has a cellular provider knows this, you will get several calls in the course of a day from persons who have your number and they have no personal or professional relationship with you. They are calling you about all sorts of things, insurance and products, and they oftentimes try to present themselves as persons that you've had dealings with prior to their call. And this is one of the main ways that people target persons for criminal activity, scam calls or spam calls to your cellular phones. So I do want to caution you about that. But while we're talking about your emergency preparedness kit, what should I have? Well, immediately you need to make sure that you're doing the things that secure your person. So if you are a person that has a need for medication, you should make sure that you have medications as a part of your emergency preparedness kit. You should make sure that you have at least a 5-day supply, considering the fact that it's very difficult sometimes to get back to your home after a disaster. And then also very difficult now to get medications at pharmacies quickly. Oftentimes there's a wait or delay in your ability to get those medications. What else should be in my emergency preparedness kit? Birth certificates, social security card, marriage certificates, and any other legal documents you deem important. Certificates of title for your movable properties, deeds and titles for your home or other immovable property. And if you have any type of citizenship documentation, you should most definitely have that with you as well. Policy information, hospitalization and insurance information, life insurance. Also, another important facet that you should include in your emergency kit is a copy of your passports or checkbooks for financial institutions. Following Hurricane Katrina, many individuals were displaced and unable to access their financial records because they didn't have account information. And so they had to wait until they were able to get other identifying information before they were able to access their accounts. So it is important to have information about your financial institutions in your emergency kit. If you possess stock certificates, mutual funds, or bonds, you should also include that information in your emergency kit. I know that sounds like a whole lot, and actually it could be. But if all else fails, have a list of these things so that if you need to have something that's very compact or concise, you may only have a couple of things, but the required information or necessary information is listed in your list. So this is an important part of being prepared. Now, I'd like to go back and just say one more thing about that targeting of criminal activity, because I want to make sure that we're very clear about this. Following a natural disaster of some sort or some sort of severe weather event that has forced you to have to maybe evacuate your home or forced you to not be able to communicate with your business endeavors or people that you conduct business with regularly in the manner that you usually would do so, please be hesitant about those phone calls. Again, I want to go back to that because this is a time when you will find that you're in necessitous circumstances and people will take advantage of you, and you will think that they are trying to assist you and they are actually targeting you as a victim of fraud. The next thing you should have after you have planned and prepared your list and you have all of your documents together, have an exit strategy. Make sure you know how you're going to move if you need to make any type of movement. You should have a team. We're stronger together than we are alone. You should have a team member and a team leader, someone who's responsible for coordinating for you in the event that you need to evacuate your home. Well, I know who my team is, I know who the leader is, and how we would coordinate or who would be responsible for coordinating. So then you should ask yourself these questions. Do I have my team members' contact information? Do I have immediate access to those important team members? Do they have immediate access to me? Is it readily available? You know, what is your means of communicating with them and contacting them? If it's your cell phone, do you have everyone's number in your cell phone? Because if your means of contact is your cell phone, but you have their numbers written in a notebook, you may not be readily, the notebook may not be readily available. So your contact information needs to be aligned with your means of contact. So you should make sure that you have this information readily available to you. You also need to make decisions about your exit strategy. Will I leave my home? If so, how will I leave my home? What's the threshold determinant of whether I need to leave my home? And once I know that I do need to leave my home, where will I go? What preparations or plans do I have for where I'll stay and how long I'll be there? And you should always make concessions for your health and your well-being. Those are paramount concerns. If you know that you require certain living conditions or certain standards because of health or well-being issues, then you should plan earlier and often. You should make sure to update your plan. If we are faced, usually I tell people Louisiana, we get hurricanes, but at least we know they're coming. Usually you've heard on the weather, we're expecting a weather event, we're expecting this. It's not like some areas that experience things, and I call it a live experience. You don't have an opportunity to prepare. Tornado, earthquake, and the like. So when you realize that we have extreme weather coming, make your plans early. Revise your plans often. Make sure that the people that you are depending on know that you're depending on them, and make sure that the people who are dependent on you know what your plans are. Um, I have here other things that are emergency preparedness needs. I didn't include them as the kit because we were talking mainly about your financial planning and well-being. But here is a list of emergency needs that you should have, maybe not necessarily packed away in a safe spot. These are things that may be in your garage and you can pick up on your way out. But it is important to have this packaged as well. And here I've included some things for personal hygiene, and also for children, if you have children in your care. The medication prescription I can't stress the importance enough of having at least a 5-day supply of the medicine that you take and that you keep. And if you ask your healthcare provider, is it possible for you to get an additional 5 doses of the medication for emergency situations. I found that doctors respect that and will provide you with that. So you usually do not have a problem with getting extra if you need it, or you may decide that you will pack prior to before you go. But you should always make sure you have flashlights and extra batteries, lots of water, your radio, your lantern. This information isn't new information. Louisiana has an emergency preparedness guide, and you can go on the Louisiana Emergency Preparedness website and get this guide, or you have it here if you want to obtain it from this list. But your glasses, plastic sheeting, soap, whatever personal items you need, protective clothing and rainwear, car keys and keys to the place you may be going, whatever arrangements you've made for your care. You should always try to have some ready to eat canned meats, fruits, and vegetables if possible. Because one of the things that we also know is that after a natural disaster, grocery stores are impacted too. They can't get their deliveries in. So oftentimes they don't have adequate stock to provide for everyone's needs. And so you have to rely on some of what you already have. So you should always prepare yourself for the possibility that you may not be able to buy new things. I don't have this on here, but you should always have cash if when possible. Make sure that you have cash for those instances where ATM machines and banks may not open immediately. You will have cash available to cover some of your immediate needs. And of course, as many forms of identification as you have. If you have a driver's license and an identification card, I suggest that you make sure that at least your identification card is in your safe spot. In the event that you forget your driver's license or you lose it, you have another form of ID. So make sure that you have forms of identification as well. Now, I've been talking about the beginning tools for life plan. Emergency preparedness is something that we should all do, young or old, in between. We should always be prepared for these unexpected events and make sure that we have our emergency preparedness kits and toolbox. And that kind of goes in with the insurance because it's an early deterrent per se. We all purchase life insurance not because we want to have to use it, but because we know we need it. We know that it's inevitable that we're going to pass away. But there are things that you can do during your lifetime that will assist you as well. And making plans for your future. And so I'm going to turn it back over to Professor Lestache to talk about some of those plans in the form of directives.
Okay, so I want to talk to you about powers of attorney and living wills, or sometimes we refer to them as advanced directives. But let me start off with powers of attorney. Next. Okay, so in looking at a power of attorney, there are just four basic things that you are considering. First of all, that if you should become incapacitated, a power of attorney serves as a form of protection for you and helps family members in ensuring that protection is given to you. Second, the power of attorney allows someone to step into your shoes to make decisions. Third, the power of attorney is a serious appointment, and it's one that you have to think about and make a decision based on who will act in your best interest and in good faith. And fourth, if you do not appoint someone, and if you do become incapacitated, then the court can step in and the court can appoint somebody to act as a curator to handle your affairs. You can go to the next one. So Power of attorney. I want to say something before I even talk about the specifics of a power of attorney or advanced directives, living wills. And this is that these should be drafted, these should be discussed with, these should be considered with an experienced attorney and you, so that you can discuss the importance of this, the alternatives, which some of them provide, and you are well informed of the importance of this decision if you choose to make it. The reason that I bring that up is because, unfortunately, quite frequently, I have someone who will come to my office with one of these documents, which are to be notarized. And they have sat down with a notary who has explained to them the importance or the impact of a particular document, and the information is incorrect. So a notary does not have the legal expertise to give you the information that you need to adequately make a decision of life importance as it relates to powers of attorneys, living wills, advanced directives. Please consult an attorney if you want to have one of these legal documents drafted in your behalf. So with that, I'll talk about powers of attorney. So a power of attorney, what is it? A power of attorney, I guess the most simplistic way to put this is that a power is a person who steps into your shoes to do what you want done or what you would have done if you were able to make that decision. So it's a decision that you shouldn't take lightly. It's a decision that you should think about and figure out who will do what I want done with my life, with my property, with making those life decisions which might affect me. So it's a decision that you have to make. It's a decision that you have to make, whether that person is in your family, whether that person is outside of your family. It's one that you have to determine who will act in my best interest, who will step in, and I repeat again, who will step into my shoes and who will act on my behalf in good faith, So I don't think most of us sit down and think about what will happen if I become incapacitated. Will I become incapacitated? But it might happen. Sometimes you have situations where someone has an illness and they know that that is a progressive illness, so they might consider a power of attorney. Or someone may be at the onset of an illness and they might decide that this is a step that I need to take. So there's different types of powers of attorney. There are 3 specific types of powers of attorney that you can consider. So the types of powers of attorney, and you can go to the next slide. The types of powers of attorney are a general power of attorney, which I'm going to talk to you about first. The general power of attorney covers a vast array of different areas that the attorney can assist you with. I pulled a power of attorney that I have right before this began, just to give you an idea of the different areas: business and affairs, correspondence, banking, securities, loans, property, mineral rights, judicial proceedings, successions, agents and proxies, claims, creditors' meetings, donations, tax returns and related matters, medical decisions, insurance, and any other general provisions that you may think of. It covers all those things that might affect you. With a general power of attorney, it would cover everything. You're literally saying, step into my shoes and handle everything and anything that may affect me, that may become an issue in my life, and I need you to make that decision for me. And that decision would have to be a decision that you know I would want made in my behalf. The general power of attorney is durable, or the general power of attorney is a springing power of attorney. Now, the difference is that a durable power of attorney goes into effect immediately. So if you are, as I said before, if you are met with an unexpected illness, and it's a progressive illness, and you want to ensure that your affairs are taken care of and that you are taken care of, and you want someone that you trust to start handling your affairs immediately, then you can enter into a general power of attorney. And in that general power of attorney, if it's durable, it will go into effect immediately. The person will handle all of your affairs. Anyone who wants to discuss any matter with you will have to discuss that matter with your designated power of attorney. That person can sell your property. That person can enter into contracts on your behalf. That person can handle your banking matters on your behalf. So this is a serious decision that you're making in terms of who and when you would want a power of attorney to go into effect, if in fact you feel that it's necessary, and if in fact you feel it is necessary and immediate. Is it durable? Does it need to go into effect right now? And that depends on your circumstances. There's also another general power of attorney, and it's called the springing power of attorney. And a springing power of attorney does exactly what it says. It springs into existence when needed. So if you feel that I'm fine, but possibly I'll go back to the same scenario. I have a progressive condition. And with that progressive condition, I may get to, or I will get to the point where I am unable to make decisions myself, or I don't feel comfortable making the decisions myself, and I want someone else to bear that weight for me, or I want somebody else to bear that weight because I don't have the capacity to do it any longer. And that capacity can be twofold. It can be mental capacity, or it can be physical capacity. I've had persons that I've done with who've had strokes. And during that stroke, they've lost certain physical movement. They've lost the ability to speak. Now, they've had someone else step in as a power of attorney. But I've also, in those circumstances, had persons who have said, but I want to have a springing power of attorney. And because if I do recover with rehab, then I want to revoke that power of attorney. So a springing power of attorney will spring into existence when needed. And a power of attorney can be revoked if you choose to revoke it. A power of attorney can be revoked if there is, if the person who is the present power of attorney is not acting in good faith on your behalf. So it's given, what is given can also be taken away. A power of attorney lasts for the duration of a person's lifetime. Once that person is deceased, the power of attorney ends. In talking about the choices that we made, or the progression of life decisions that we make. Many times people think that a power of attorney extends when a person is deceased also, and it doesn't. So what I see happen more often is a child, the parent is deceased, and then they need to access a bank account, and they'll go to the bank and they'll say, I have a power of attorney. And the bank will say, can't accept it, because the power of attorney is no longer any good. It ends when the person's life ends. So you have to make those other decisions, possibly having your name on the bank account, also in case of an emergency situation such as that. But making that decision, who is going to be the power of attorney, and knowing the power that that decision holds with it in allowing someone to handle all your affairs, is very, very important. It's also important, again, to figure out, do I want this power of attorney immediate, or do I want this power of attorney to spring into effect should I need it? Next slide. So there are other powers of attorney. I said there were 3 different types of powers of attorney that you can have. You can also have a limited power of attorney, and you can have a healthcare power of attorney. It can also be some other, it could be a medical, not a medical, it could be a business power of attorney. But a limited power of attorney allows you to limit what it is that you want the person to handle for you. It can be in general terms in which you are specifying a specific act, such as this, that they're selling property, that you want them to handle the selling of your property for you, or entering into a specific agreement on your behalf and handling those types of affairs for you. Or it can be a bit more general, and that general and general in terms of I want you to handle my business affairs for me. I've had 2 circumstances which pop into my mind with regard to the limited and more general powers of attorney. In one circumstance, I dealt with a situation in which an 18-year-old is an adult in the eyes of the law and can make adult decisions, but the 18-year-old was still in school. One parent said, I want you out of school right now. The other parent said, I want you in school right now. And the child who's 18 but can make that decision decided to execute a power of attorney. And in that power of attorney, he wanted the parent to make the decisions, one of the parents to make the decisions with regard to his education. And so that was drafted to him so that that parent could make those educational decisions for that child, and they could stay in school beyond the age of 18. Other powers of attorney that I have dealt with, people who have had strokes and who have anticipate that they will get better. And most people will get better, but they anticipate that they will get better. So they want to ensure that that power of attorney is limited. And it might be limited to just healthcare concerns, or it might just be limited to business concerns. And they are the only legal issues, or the only agreements, or the only matters that the person given the power of attorney is able to handle. So So you can give that limited power of attorney or that healthcare or specific general power of attorney to a person to act in your behalf. Again, if you do choose to enter into a power of attorney, please use a licensed attorney. The power of attorney has to be signed by witnesses. It has to be a notarized document. It does not have to be filed. It needs to be put in a safe place, but some people choose to file a power of attorney. For example, if you have property, you may want to put third parties on notice. And because of that, you may want to file it in the mortgage and conveyance records so that they know that if you're interested in this particular piece of property, you have to contact the person who has the power of attorney. So it serves as a protection for you, and it serves as an aid for you. But again, it's not a decision to be taken lightly, but it comes in so many different varying forms in terms of immediacy, in terms of springing, in terms of the limitations that can be placed on it, that it's a very effective, powerful document that you can use as an aid in that progression of life plan. So moving on to living wills. Next. Thank you. Living wills and advance directives. Living wills and advance directives are somewhat the same. They're letting a person know in advance what you want done in case you should become incapacitated. And again, it's a difficult topic, and it's one that most of us don't sit down and think about, but it's one of those unexpected things. And sometimes it's one of those expected things that can happen to you during your life. The living will is a document that tells doctors and everyone exactly what you want done if you are unable to communicate with them due to being mentally incapacitated. The living will or the advance directive, it must be notarized. Well, it doesn't have, let me just say, it does not have to be notarized, but it is in your best interest to have this document as the power of attorney notarized, witnessed by two persons who are not going to inherit from you. I stress that, who are not going to inherit from you. Because if you are going to receive some benefit, if the person should pass away, for obvious reasons, you do not want to appear that you made a decision to advance any advantage that you may have in their death. So that takes that off of you. But what an advance directive living will does is it lets other people know this is what I want. Powers of attorney, advance directives are documents that help the family, because it becomes very difficult during these time periods for family members to make that decision. If you need life-sustaining equipment, if you need some type of life support, if you are in a situation in which a decision has to be made with regard to whether you should be resuscitated or not, it takes the pressure off of your family. It helps them do what you want them to do, and it helps them not feel guilty about that decision. It helps them serve you. And it's a way for you to control your life should you become in a situation in which it is compromised because of incapacity in some form, whether it be physical, whether that be a mental incapacity. You can go to the next one. And I think I already talked about this, but that's okay. So the living will or advance directive must be signed by 2 witnesses who do not inherit. And I already said that. Notarization is not required, but it's recommended. And it's recommended because when you are making that decision, when you give that document to a doctor or some facility, they can see clearly that this is the directive or this is the living will of the person who is specifically affected, and this is their wish. Do you want extraordinary means used to prolong your life? Do you want to be resuscitated? And are there certain medical procedures that you do not ever want to be performed on you? Hard decisions, hard to sit down and think about them. Most of us don't, but there's things that we need to do in order to, again, put our life in order, look at our progression of life and get our house in order so that it makes it easier on ourselves. It also makes it easier on our families in making those decisions and being able to carry out our wishes so that our progression of life, which, you know, it's get blows from the expected and unexpected, is easily no, I'm not going to say easily, but is given some guidance, and we know what to do, and we're able to carry out the wishes of our loved ones. Next. So this leads us into the topic of estate planning, and Professor Charlie Kane will discuss estate planning.
Good evening, everybody. Estate planning. Before I get started, I learned an old adage a few years ago, and I think it's still applicable now. If you fail to plan, you plan to fail. Let me say that again. If you fail to plan, you plan to fail. You have to have a plan. What is estate planning? Estate planning simply is getting your organizing all of your personal financial affairs. Another adage says that it's not what you make, it's what you keep. And if a lot of your finances are going on late fees, filing fees, and all kind of court costs and all that kind of stuff, that can be a bad situation. It has been a bad situation in a lot of situations that I've seen. As it's been stated in this seminar, is that most people don't like to talk about estate planning. They figure it's morbid, it's depressing, but most people probably don't know that there are basic goals in estate planning. Estate planning shouldn't just take place when a person is anticipating death, but estate planning should take place even during lifetime. To maintain your property and protect your property during your lifetime. I've noticed that it seems like Louisiana is having a lot of tornadoes. I guess in the past it's been about hurricanes. But, I was down at the Superdome when after Katrina and all that, and I saw a lot of devastation down there. So everybody that's in the sound of my voice should be involved in estate planning to maintain and protect your property while you're here. People go to work, they don't anticipate getting hurt. People traveling from state to state, they don't anticipate getting hurt, but it happens, it's a reality. So estate planning has 2 main goals: to protect your property during your lifetime and provide for orderly disposition of your property after death. What are the methods how do we plan? How do we plan our estate? Well, one, we make a list of the properties and we organize a personal record. I've listed some of the items that we need. Next slide. Here are some of the items that we need. And this is not a conclusive list, but it's some very important documents. Birth certificate, Social Security numbers, marriage license, divorce papers, custody and child support judgments, latest will and testament, bank account, income tax records. These documents, like I said, it's not conclusive, but they're important documents. You might have some that's not on this list, but they're important documents. I think insurance was mentioned in the past, but definitely I've seen some real bad situations happen because beneficiaries weren't updated. They weren't updated, and situations where there were two brothers that was living in a house, their mother's house, and they were paying insurance. They were paying insurance payments, but then, they had a fire and the insurance company didn't want to pay, even though they had been paying the policy. So updating, beneficiaries, very important. Another thing I've found to be very important, I don't think it's on the list, but joint bank accounts, very important. As Professor Lestache stated that, we have to make sure these documents are very powerful documents. We have to make sure that we get someone we can trust, okay? So having all these documents together, I saw a lot of it when I was, down at Katrina at the Superdome. People didn't have dockets, just getting some of these documents and putting them in a safe place. They're going to relieve a lot of stress on your loved ones. So it's very important. Wills. Well, what are wills? What are wills about? You heard that term. There's different types of wills. Will is just a statement saying who you want to administer your property once you're no longer here, and who you want to give your property to. That's basically, but there are various kinds of wills. Usually when we talk about wills, the question always comes up, well, can I draft my own will? And yes, you can. Louisiana got some laws that say that you can do that. But when I'm asked that question, I always follow up with, let me give you a situation. You got a serious abscess and your jaw is all swollen. Who are you going to go to? Are you going to call me? Or are you going to go to the dentist? Or are you going to try to pull it yourself? So there's a provision where you can do a will, but there's another, that we have statutory wills. We used to have a bunch more, but I think they limited it basically. But the statutory will is the best will, in my opinion, okay? Because I think Professor Lestache talked about watching them notaries at, particular grocery stores here in town. You want to watch those, especially when you start talking about legal documents. So, you can do a will yourself, but, I wouldn't suggest that. Now, when you got all your information together, there's a few other areas that you need to know about. In the state of Louisiana, people die either one or two ways. If you die without a will, it's called intestate, and the state will determine, who gets your property. And if you die testate, that means that your property will basically go the way and who you want it to go to, okay? You should also have basic knowledge about the types of property in the state of Louisiana. Louisiana has community property and separate property. Generally, when you have community property, that can happen during a marriage, and separate property when you're single. Okay, so basically you need a general understanding of the property. Louisiana even called property immovable or movable property. But, you know, basically, if you have a valid will and it's done by, you know, a proper attorney, then your property is gonna go to who you want it to go to instead of being a contest. Now, separate property, community property. I think I talked about that I wouldn't recommend, you know, someone trying to do a will themselves. And the reason for that is because Louisiana is a limited forced heirship state. And what does that mean? That means that Louisiana, if a person in a family, if they have an heir under the age of 23, and they're called a forced heir. So most people that doesn't have a knowledge of that concept could be in trouble trying to do a will themselves. Because if you don't recognize the forced heir, then that will could be subject to attack. Now, also, that forced heirship could be extended. If there's a child in the family and the child has a physical or mental impairment, then the forced heirship concept can be extended for a lifetime. That's the reason people that try to do wills themselves run into problems. Also, depending on whether the property is separate or community, you could have a situation, especially with if there's no will, then you have an issue, they call it the 890 usufruct, which means that property go intestate, the law determined first to the descendant, and there's an 890 usufruct, and things that most people that don't deal with law, they don't know about. So you got to be careful about drafting legal documents yourself. One of the questions that always comes up, especially in doing wills, is that should it be filed? I think Professor Lesage just talked about that. Well, when I'm asked that question, I say it's personal. Got a situation right now where a will is a problem because we can't find the will. But one good thing, and I've explained the pluses and the minuses, one good thing about filing the will, that if you have a problem in the end, you got to file the original will, and you know you got a record of it if you file it. If you don't file it, and I've had situations like that, then that's a problem. That's a problem. So, and I know a lot of times people don't want to file wills because people can go down, it becomes a public record, and people can go down there and see what you're trying to do with your property. But that's kind of like a personal decision, but that question always comes up. I think I touched on burial plots. That can be put in a will. I got a note down here, burial plots. But burial plots can be put in a will. They can be burial plots. They should be put in a will if they exist. It should be put in a will. That's about. I think I've covered all I wanted to cover. But in ending, I just want to say that in estate planning, we should stay ready when we don't have to get ready. That's all I have.
This is Alicia Grace Obear again. I'm going to really piggyback off of what Professor Kane was just saying and explaining. One of the main concerns about making sure that you're dealing with competent parties when you're preparing these documents or preparing your last will and testament is to prevent problems. You know, you try to foresee as many things or plan for as many things as you can. And when you have taken these necessary steps, and you've employed some of these tools that we've talked about so far, it makes things a lot easier for your family members upon your passing. Professor Kane mentioned, and I want to make sure to go back and say this because we're going to expound upon it. People die one or two ways, to use his wording, with a will or without. When you have a will, that's an expression of your desire, what you would like to see happen and how you would like to see it happen. It also allows for your surviving family members or whomever you designate to be placed in possession of your property. It keeps your property within certain family lines if that's your desire. It also prevents what I call hard feelings or upset feelings because that is a pronouncement of your determination of what you want. And so no one should feel slighted in that they think they know what you wanted and it's not in line with what someone is doing. Your will is a clear announcement, a pronouncement, an indicator of your intent. And it is, you know, not to be snappy, it is what it is. It allows people to understand that that's what you wanted, and they're more likely to move on and be accepting of the way that your property is distributed if they understand it to be your desire. Wills also assist people in making sure that um, certain items that may be outside of the family line will go to those persons who you want to have them. So what happens is people have, once upon a passing, people open succession is what we call it. And succession is basically legal proceeding that allows persons to be placed in possession of the things of the deceased. I think that's the easiest way to say it. A succession allows persons to be placed in possessions of a deceased party. It allows for easy transition, for lack of a better word, of your things. Because oftentimes, and especially in underserved communities, we will find that people haven't had successions and the property's ownership is now muddled. And by muddled, I mean, you know, we're 3 generations from the persons whose name the property is in. And there have been several family members who would have been placed in possession by operation of law, but they've also passed on. And now we're looking at a piece of property that has so many heirs and descendants that it's going to be very hard to get a clear resolution of ownership or a clear determination of ownership. And then it becomes very costly because you're dealing with several heirs and potential heirs, and there's a need to make sure that the title is clean so that the legal owners following the succession are clear in order to avoid having what has occurred in the past continue into the future. So it's important that we look at preserving our properties and protecting our properties and making sure that those who follow behind us have the necessary documentation in order to conduct necessary transactions and to protect our estate and their legacies, because they are becoming the owners of these things. One of the main things that happens, and Professor Lastache mentioned this, but I think it's important enough to repeat, is that people come to an attorney's office to say, I can't access my mother's bank account because, you know, they're not listed on the bank account, or They haven't taken a step to to file a succession, or I can't do anything with our property following a natural disaster because we aren't eligible to participate in any other federal programming because the property is still in my grandmother's name, and we've never uh, taken the time to open succession and have the property devolve to the next set of heirs. And then they have to take those tedious steps of going back a generation or two to make sure that they're including everyone who needs to be legally included. And they miss an opportunity to participate in some of the federal funding that's available. So when you not only don't have a will, but when you don't take the necessary steps to ensure the progression of your and the devolution of your property through succession, you are jeopardizing your family's ability to continue on to preserve that property and to be placed in their rightful ownership. So one of the main tools about succession is that it prevents problems and it protects property. I've already said this, but it's still worth repeating. It's important that people engage in legal representation to file successions or to open succession. It places those persons that into possession of the deceased person's property, and it can occur by them having a last will and testament, which is what Professor Kane talked about, or it can occur by operation of law. With the last will and testament, as long as this person has expressed his or her desires about the handling and possession of their things, and it's in a valid form, those directives will be given the full effect of law. By operation of law, if a person dies without a will, his things will be handled and parceled by operation of law. What's operation of law? It means that the state of Louisiana has a set of rules in place for persons who die without wills. And if you die without a will, they have a listing of who gets what first, who has priority, is how I explain it to my law students. And that list prioritizes who's going to get what and how. And it depends on whether or not the property is classified as your community property or your separate property. But one of the most distressing things I've ever dealt with is to have a surviving spouse come to my office with things that they have spent years with their spouse acquiring community property. And then they find out because their spouse didn't have a will that naked ownership of those things don't belong to them. One half of the ownership belongs to whoever is first in line as their heirs. And they are so sure that their spouse would want them to have complete ownership of that property. But the fact of the matter is, they're going to be handled by operation of law. And under Louisiana law, when a person dies without a will, even if they're married, that property devolves to their children first. And sometimes those children are not the children of both spouses. And then we have what I call a family mess that could have been avoided by proper planning. So it is distressful to place your life's possessions, your life's work in the hands of the state of Louisiana and let the state of Louisiana make a determination as to what will happen with your things. So I often encourage people to look into getting a will done. Speak with a qualified professional who can assist you with preparing your will. Doesn't take a lot of time, shouldn't cost a lot of money, and it's worth the money spent to avoid the possibility of having your spouse be placed in a situation where things that they've worked their lifetime to help you accumulate don't go into their possession or their ownership immediately, or even being forced to post security for something that they've worked for with you because you don't have a will and your heirs may not necessarily be their heirs. So that's an important consideration in your life plan. Do you want to determine who gets what, or do you want to have operation of law under rules set by the state of Louisiana to make that determination for you? The effects of succession. Well, successions affect your property rights and your practical rights. At least that's what I call it. Your practical rights are these. Succession can affect your daily living and can impact your ability to conduct the business required to maintain your lifestyle. Why is that? Because if you do not secure the future for those who are to come behind you, then their ability to keep their home, well, keep a family home. Let's just say you want them to have your home, but you didn't outline it in a will. Their ability to do so may be impacted without um, uh, either a will or a succession done immediately. It can affect your property rights, both community and separate. And I've given you an example of that. But and again, the caveat that even though community property is owned by married persons in division, when one of those persons die, one half of that community will devolve to their heirs unless you have something in place that designates otherwise. So again, it's very important to know what you want to see happen with your things and how you want to see it happen. And if at all possible, that you put those things in a valid will, in a valid form to suffice as your will. Just to go back and cover something that Professor Kane mentioned, I wanted to mention, you can have what we call a notarial will or a statutory will. And again, it has a formality that requires you to be before 2 witnesses and a notary. We would again suggest that because of all of those things that Professor Kane mentioned, forced heirship and the like, that you speak with a qualified legal professional when you prepare or having your will prepared, and then of course, culminate by having it done by authentic act, which is a notary and 2 witnesses. So you need to make sure that you're doing that. The other way that you can have your will is it can be totally handwritten in your hand and signed by you. Louisiana accepts and respects that as an holographic will, and as long as it's completely handwritten and it's dated and properly executed, and by executed means signed by you, then it will be considered valid in form. So those are the 2 ways that you can put your desires in writing, notarial or statutory will, and lastly, holographic will. Sometimes people run into problems with holographic wills because they are not self-proving, meaning they're not automatically accepted as such. You have to go through a proofing process in order to probate them. But if you have it in a notarial form, the proof, my grandmother would say the proof is in the pudding. The proof is in the fact that you've stood before a notary and you've had people to witness it, and they are able to verify that this was Alicia Aubert's wish. This is what she said she wanted. So there's the proof, assigned to those things. So it's very important that you have all of these things as a part of your covering, as a part of your plan. If you are, a person who's okay with your possessions devolving by operation of law, make sure you understand what that devolution is. Make sure you understand the tiering, because as I said, many a married person has assumed that upon my passing, everything's going to go to my spouse. That's not necessarily the case in either community or separate property. Your spouse may have use of the thing, but the ownership will pass on to your heirs in a community property situation. So I can't stress that enough, because those have been the most distressing calls I've received, where someone just assumed that their surviving spouse would have ownership of the thing, and that's not what happens if you don't have a will. So at this time, I'm going to turn it over to Professor Fasulo. He's going to share some information about important considerations that you need to make as well.
Good evening. I'm going to talk about the different tax aspects of estate planning and successions. The tax aspects are huge. there's so many different details. If you've dealt with the Internal Revenue Service, or you've dealt with the Department of Revenue, or you've dealt with the Internal Revenue Code at all, you know that it is vast, it is complicated, it is confusing. So I'm going to narrow my discussion to the income tax issues that can pop up actually before someone passes away and after they pass away. You know, you always hear the saying, there are two things that are certain in life: death and taxes. And we're talking about both of them this evening. First of all, when planning your estate, I just want you to be aware of the different assets that a person may have different tax distinctions and different tax attributes depending on the asset. And so when someone is writing a will, planning their estate, planning, you know, my surviving spouse is going to get my retirement account, or my niece or my nephew, my son or my daughter is going to get the cash in the bank, or my savings account, or what have you. When you start, for lack of a better word, divvying up assets and planning the succession process, or planning your what you're going to put in your will, you have to take into consideration what the tax aspects are of each of the assets. And so I put in here retirement accounts versus cash. And so that's the two extremes of the spectrum. Cash that's in your bank account is after-tax money. It's money that's accumulated. You've already paid taxes on it. So whatever the balance is in the checking account, savings account, money market account, that's the cash, that's the value. As opposed to a retirement account, which has a named beneficiary. And when that retirement account is left to an individual, there are going to be tax consequences to it. So my point is this: if you have $10,000 in your checking account and you have $10,000 in a retirement account, they're not of equal value. So what I'm saying is, if you leave in your will, I leave my checking account to my son and my retirement account to my daughter, they're not going to both end up with $10,000. The one who gets the checking account will actually get the $10,000. The one who gets the retirement account will get the $10,000, and then they'll have to pay taxes on it, which means they will actually end up with less than their sibling. And so you need to be aware. And again, that's two opposite extremes, but just be aware that each individual asset may have a separate tax issue or tax liability associated with. Okay, next slide. Okay, when considering the particular assets in a succession, I do want to go back a little bit, and we're going to talk about opening up a succession. One of the issues you have to deal with is, of course, distributing the assets and things like that. Taxes are going to also be one of those issues that maybe you have to deal with in a succession. Periodically I get asked this question. My loved one passed away, my spouse, my son, what have you. How fast do we need to open up a succession? And there's no quick answer to that. There's no, within 2 weeks, within 3 weeks, within 5 days. I mean, that's not realistic. It really depends, quite frankly, on what's in the estate. Now, I'm not going to tell you if somebody passes away on a Thursday, you need to go sit down with an attorney on Friday. I'm not going to say that. And I'm not going to say, hey, you can wait till next year either. There's got to be a reasonable amount of time for somebody to actually deal with, I've lost a loved one. They're beginning kind of a grieving process. There may be a little confusion, what have you. But make no mistake, there are issues out there that have to be dealt with, and they have to be dealt with in a timely manner. So, as I said before, there's no quick magic number of days or weeks. These are just things that have to be dealt with. And so the different types of assets that maybe have to be dealt with once a succession is open are going to be the stocks, bonds, mutual funds, real estate, oil and gas royalties, different contracts, businesses that need to be operated in the sale of assets. These assets continue to do whatever they were doing while the person was alive. Now that the person has passed away, those stocks still produce dividends. Those mutual funds still pay dividends. Those bonds still they still pay interest. The real estate still needs to be taken care of. The oil and gas royalties still come in. Contracts still need to be paid. The businesses, somebody needs to oversee the business. Maybe there needs to be a sale of assets. And so when you're talking about these types of assets, not only are we talking about that tax attributes, but we're also talking about an estate that is opened and needs to be under administration. So what does that mean? That means when an estate is open, an executor of the succession needs to be appointed, and they need to be aware of the different types of assets. And there's a process for the executors to do that. Most of the time when I deal with executors, they're just a person of the family. It might be the surviving spouse, the son, the niece, the nephew, whoever usually is kind of more of a financial savvy person. They don't automatically know what to do. That's why they come see an attorney. And so the attorneys usually walk the person through what needs to take place. But the succession representative or the executor or the executrix needs to be aware that assets that are producing income for the succession, or excuse me, the assets that were producing income for the deceased are now producing income for the succession. And so anytime income is being produced, unfortunately, there needs to be a tax that has to be paid. So realistically, income tax returns have to be filed depending on the situation for the succession during the administration. So think about this. When someone passes away, and nobody passes away on January 1st or December 31st. So there's always going to be time period where income producing assets produce income before they pass away and after they pass away. And so a person that passes away, of course, their final tax return, their final individual tax return needs to be filed. And so for the most part, whatever income was produced before they passed away will be reported on their tax return, as long as along with notifying the IRS that the person has passed away. Social Security needs to be notified as well. Now, again, as those assets continue to produce income, certificates of deposit, stocks, bonds, what have you, the income needs to be accounted for in the succession. The executor needs to be aware of those assets that are producing income. And at the end of the calendar year, the succession is going to have to file an estate income tax return to account for that income. And so that's one of those things where, quite frankly, a lot of people don't realize it. A lot of people don't realize that an income tax return needs to be filed. And so sometimes the succession ends up being closed if the executor is not guided by a competent attorney and directed and told, hey, you need to file an estate income tax return, then those taxes will have to be paid after the succession is closed. And unfortunately, the heirs will have to come up with part of their inheritance to pay the taxes. Income tax returns will need to be filed on an annual basis, even if the succession is open for more than a year. Some successions are open for 2, 3, 4, 5 years and more. Each year that those assets are producing income, a succession has to file an income tax return. Okay. Now, who pays the taxes on those income? Well, that's a very good question. The estate is going to pay taxes on the income unless the executor, with permission of the court, distributes that income to the heirs. If the income is distributed to the heirs during the administration of the succession, then yes, the estate will file an estate income tax return, but it will only report who got the income. It won't actually pay a tax. It will just report to the IRS the name, address, and social security number of each heir and how much income each heir received. Once that is filed, then it is the heir's responsibility to report that income on their personal tax return. So you can see, and you can probably kind of see one of these successions that has different types of assets, different types of income. If it drags out for various reasons, multiple years, this can kind of get complicated and can get hairy a little bit, especially if there's a question as to who the heirs are. Okay. The decedent's final tax return will be filed in the year that they pass away. Once that is filed, no further tax return is needed. The succession's income tax return is the 1041. Sometimes it's referred to as the fiduciary return. And the reason why it's called the fiduciary return is because the executor or the executrix is in a fiduciary capacity. They're to act in the best interest of the estate and in the best interest of the heirs. One of the last things I'll talk about in this section is sometimes under administration, Assets need to be sold. That's part of the administration of the estate. And sometimes that produces an income tax. Okay, and so just be aware of that. Next slide, please. So when we're talking about the succession, selling property and things like that, there's something called tax basis. And it's a it can be a very complicated phrase. It can be a very complicated concept, but I'll do my very best to explain it simply. It is the new cost basis that we use to determine, do we have a gain or a loss when we sell an asset? So think about this, and I tell my students this: we have a three-pronged equation when we sell something. We have the sales price, we have the cost, and we have what's left, the gain or loss. And so consider the tax basis of property that's being distributed to the heirs. So when somebody passes away, what is the tax basis? Well, when you inherit something, your new tax basis is the fair market value of the asset on the date of death. So we just talked about in the previous slide, the stocks, bonds, mutual funds, real estate, royalties, businesses, things like that. Well, if the estate sells those assets, or if the heirs inherit that property and they decide to sell it, then what are the numbers that we actually plug into our three-pronged equation? Well, we know what the sales price is going to be because we're putting up for sale. Stocks, bonds, and mutual funds, we call the broker, we say, sell this. So we know what the sales price is going to be. But what is our tax basis? How do we calculate whether we're going to have a gain or loss? Well, that's why all assets need to be appraised as soon as practicable, right after somebody passes away, to establish the fair market value on the date of death. Now, the reason why we have to do that again is because you get a step up in basis when you have inherited assets. And so here's my example: Exxon stock. Tons and tons of people own Exxon stock. When somebody passes away, Exxon doesn't stop paying a dividend because somebody passed away. They continue to pay the dividend. Not only that, if that stock had been owned by the deceased back, let's say in the 1960s, well, their tax basis or their original cost could be $10. Well, Exxon's somewhere around $80 to $85 now. Okay, so if we didn't keep track of this basis, then they would literally have a $75 gain per share. But when somebody passes away, they have a step up in basis. So if the fair market value of Exxon stock is $85 on the date of death, then their tax basis is $85 on the date of death. So when they sell that asset, sales price is $85, could be $95, could be $75, whatever the sales price is on the date of death. But their tax basis is $85. And so theoretically, if they sell the asset for $85 and their tax basis is $85 because of the fair market value of the date of death, they have no gain or loss. And now this is Exxon stock that was originally purchased by the decedent back in the 1950s or 1960s, and they paid $10 a share. So that all of that gain escapes the income tax. But the only way to handle that is to make sure that we have the fair market value on the date of death so we can have the step up in tax basis. Okay. And that's why I'm saying the new fair market value becomes the new tax basis of the assets. Basis is used to establish gain or loss on the sale of the assets, whether the assets are sold while the succession is still open or after the estate has distributed to the heirs and the heirs sell the assets at any time in the future. At any time in the future. So what I'm saying is, when somebody inherits a piece of real estate, stocks, bonds, an oil lease, it doesn't matter what it is. When they inherit the property, they may actually own it for 20, 30, 40 years, and then they sell it. Well, we'll have to go back 20, 30, 40 years and look in the succession that they inherited it from and find out what was the fair market value on the date of death. All that is part of the administration. Now think about this, and we'll just take this one step farther. If somebody here inherits that stock, it was originally paid $10 a share. The new person, the new heir, the son, daughter, surviving spouse inherits that stock. On the date of death, it's worth $85 a share. And that person lives another 20, 30, 40 years. And then they leave that asset in their will to their kids or another surviving spouse. Then they get another step up in basis to the fair market value on their date of death. And so theoretically, if these assets are inherited by multiple generations, the step-up basis continues. So just to kind of recap, there are a lot of different tax issues in dealing with successions. Specifically, we're talking about income taxes for the estate, the different mix of assets. Assets are not created equal. If someone wishes to leave equal assets to their kids, just remember that cash in the bank is not necessarily equal to the fair market value of cash in what we call a qualified account or retirement account. Cash in the bank is after tax. Cash in a retirement account is before tax. Then when we're talking about the different types of income that is produced by the different types of assets, that income has to be accounted for however long it takes for the administration of the succession. Okay. And then lastly, the very important going forward is the step up in basis. And so the fair market value needs to be established. And so some of the assets, it's relatively easy to find the fair market value of the date of death. Like I said, stocks, bonds, and mutual funds, we just look on the stock market and see what it's trading at on the date of death. Real estate, oil and gas leases, those types of assets, royalties, businesses, those all need specific appraisals. So I'm going to go back to my original opening statement. I'm not going to tell you that when somebody passes away, you need to go open the succession and establish an appraisal within a few days or a few weeks. And you need to do it as soon as practicable. Everybody deals with passing of a loved one differently. But as a practical matter, there's some things that need to be taken care of within a reasonable amount of time. Okay. And so that's pretty much the income tax aspects that I'm going to talk about. I'm going to go ahead and pass this on to Professor Aubert. She's going to be talking about trusts.
Okay, so thank you, Professor Fasulo. This is just a very basic discussion about trusts. Trusts allow you to shelter your income and property to protect your assets. Trusts are instruments that can protect your assets today and also allow you to provide financial security for someone after you have passed. There are several legal, financial, and tax implications when you are creating a trust. Some people believe putting their assets in trust will allow them greater access to Medicare services in years to come. But I just want to let you know, as a part of this general discussion, that the federal government looks at the previous 5 years of income and asset history before they make a benefit determination. So, a quick decision to put your assets in trust may not garner you the result that you're looking for if you're talking about Medicare benefits. But the most important thing that I can say about trusts is that they should be considered with the guidance of someone who is trained both in the law and the tax implications of a trust arrangement. Because depending on the type of trust and what you want to do with the trust, the rules that govern them, are different. So we didn't want to end our presentation without talking about what trusts allow you to do, which is shelter your income and property and protect your assets. But we do want to advise that you speak with a professional who is versed in both the law and tax implications when you are considering establishing a trust. Professor Lestache?
All right, thank you. Before I open it for questions, something that I just feel that I have to say. Excuse me. When Frances was, when she opened up, one of the things that she mentioned was that you are looking at the issue of generational wealth. And Louisiana, as many other states also, Louisiana is just plagued with disasters. And we have a disaster relief clinic. But the disaster relief clinic was formed after the flood of the Great Flood of Louisiana of 2016. And I just want to say this, during that time period, we provided service, and I'm just talking about disaster service, to 450 people over a few months, a short period of time. And the large majority of the people who had problems revolved around succession issues. And one of the biggest issues that they had was generation after generation after generation had someone who had passed away in their family. And it was always, well, I'll worry about that tomorrow. So in talking about those things that are expected, unexpected, and those plans which you need to put into effect, and the information that has been given to you in this presentation. A succession, as Professor Fasula said, doesn't have to be done tomorrow. I mean, immediately thereafter, like the next day, the next few days, even the next week. But a succession is something that is a must. Going back and recreating, finding heirs and doing successions over multiple years is a major task. And that was one of the biggest issues and one of the major issues that we were struck with in trying to assist persons with disasters, successions, and the failure that we have in always assuming we have tomorrow, and tomorrow is a year from now, tomorrow is 2 years from now, 10 years from now, or what have you, and going back and recreating that. So handling your business, getting your house in order, and doing a succession within a timely manner is a great, you're putting yourself in a great position of advantage in taking care of that, because you just don't know what is going to happen. And when you are faced with that difficulty, you'll wish that you had taken care of that in a timely manner. But that's one of the major things that we constantly see is the issue of successions always being put off. And with that, I'm going to go to the chat, and I will start with the first question. The first question is, do you have any recommendations for a good fire-proof, waterproof safe? And I guess that would be Alicia. I have something I want to say about that too, but go ahead.
Okay. I recommend a bag. It's and I love Amazon. So I know that there is a bag on Amazon that it's called Fireproof Waterproof Bag, and you can get it in various sizes depending on the number of documents you want to keep in the bag. But it'll hold most legal and letter size documents. It's something that you can pick up really quick and take with you, drop in a big handbag, and it's ready to go. So if I had to make a recommendation, I would say look at Amazon and go and look up water and fireproof bags. And they'll have a selection there. And some of them, they also have safes as well that they indicate they're fireproof. So, but I like the fire and waterproof bag.
And this is just from experience. We had purchased a safe, and we did not check to see if the safe was waterproof, humidity proof, and we put loose documents, very important documents, in the safe instead of putting them in a bag and then placing them in the safe. And because they weren't waterproof / I guess humidity proof, a lot of our important documents were mildewed. So that's a great question, because just placing them in a safe, as I found out myself is not good enough. Having the appropriate protection in putting them in some type of a container which will preserve them, or putting them in some type of a safe that specifically provides for that protection is important. Next question, will pictures of these documents on a cell phone be a good substitute for having the actual document? And Alicia, I believe that question would go to you also.
I would say yes for most of the documents. It'll get you in the door, I guess you would say, in an emergent situation if you have a copy of your birth certificate. But if you're going to have these things as pictures on your cell phone, you also need to make sure that you're going to have a means of being able to print them off your cell phone, because oftentimes they don't just want to see the copy, they need to actually be able to receive a copy of the documents that you have when you go to places to reestablish yourself or to get copies of other financial paperwork. So I think my answer is it depends, but I do know that when you go to like the Social Security office, they want to see it, but they also want to make a copy of it. So you would have to be able to print off a copy of what you have on your phone if you had to leave a copy, you know, at an establishment in order to do whatever it is you're trying to do.
This next question, I believe, would go to either Professor Aubert, Professor Fasulo, or Professor Kane, because it deals with an executor, and all three of you discussed an executor. When the executor of your estate does not follow your wishes to the T, who oversees this process, and can the executor be forced to comply with your wishes, i.e. requested cremation, and executor ignores this request? Who wants to answer that question?
Professor Kane?
I would think that, and I read that, I'm thinking that it would be one of the heirs. It would be one of the heirs that's in the will, or legatee would go in and have to file a motion to make them do what the will requests.
Right. I'll join in there to say that when you say following the decedent's requests, if there are written requests that are a part of his will, his last will and testament, and the directions that are given as a part of that testament aren't being followed, then the recourse is to file a motion in opposition with the courts and try and force the executor to do what he or she has been tapped to do. But if it's a situation where this is just something that you know that the person said to them and it's not written in the will, then it's very difficult to prove that someone is acting outside of the instructions that they're given. So that's another reason or another example as to why, if you have specific wishes, they need to be outlined in your last will and testament.
And let me add on to that. In the state of Louisiana, it is required that you must have a notarized document authorizing the cremation. So if you do wish to be cremated, some sort of notarial act needs to be drafted, whether that wish to be cremated is placed in a living will, possibly, or just even in the power of attorney, or in a succession document. I mean, not the succession document, in a will, a notarial will, so that your wishes with regard to what to do with your remains can be carried out. But Louisiana does require that some form of notarial act must be drafted in order for a cremation to take place. And again, you know, with regard to what the other professors have said, can the executor be forced to comply with your wishes? First, again, it's in a notarial act. Secondly, the position of an executor is, in fact, to carry out your wishes.
Exactly.
So the executor cannot go out on a whim and fancy and just decide, okay, I want to do whatever I want to do. You appointed this person as executor because you assumed that this person would act in good faith to carry out your wishes. So that's one of those decisions that you make, and a choice that you make in determining who is best able to and who will carry out my wishes upon my death, or again, if I become incapacitated.
Okay, if I understood the question correctly, I think the person that asked that question wants to know who would enforce that against the executor. Okay, I'm thinking it would be either an heir or a legatee would come in there and file an action to say, hey, they want to be cremated and the executor is not doing that.
They would, yes. I mean, somebody could come in and challenge that. However, the executor's responsibility is to carry out the wishes of the decedent. That's why they were chosen. So I'm just saying that.
See, I had a situation like that where the wife was coming in there, the family was going to go with cremation because they had brought him from California to Louisiana, and the wife was legally married, and I found out that they had been estranged for about 4 or 5 years, but she wanted to force the family to do a Christian burial. And, once I did a little investigation, they didn't care. They just said they wasn't spending any more money. And if she wanted to do that, she needed to pay for it. So, we dealt with that right away.
The next question. Whoops, it jumped. Let me see, I'm trying to get to these questions. The questions jumped. Okay, in establishing a last will and testament in Louisiana, does one have to leave a legal child an inheritance?
No, you don't have to leave a legal child an inheritance unless the child is a forced heir of some sort.
Right.
Which Professor Kane talked about, and generally is a child that's 23 or younger, hasn't attained the age of 24 yet, 23 or younger, or they are a child who has a severe disability that makes it such that they can't take care of their person or their estate. They are also forced heirs, and the law provides provisions where they can inherit. But if a person does not want to leave their child anything and they are over that age and they don't suffer from some sort of physical or mental incapacitation, then they do not have to leave them anything. But they would need to have a will in order to enforce that, because if your property devolves by operation of law, your children are your first tier or first priority heir in a separate property and community property situation.
Okay, the next question, and I do believe you probably would have to consult an attorney with the next question regarding the death of a mother and the succession, the house and things of that nature with regard to that. As far as the part in the question that deals with the succession cost, it just varies from jurisdiction to jurisdiction. So that's not something that can be answered. It also, the assets of the succession also come into play with that. So that one you would have to consult an attorney.
Which one
does
is
the clinic, just hold on, Professor Kane. Does the clinic offer assistance with will writing, and who can be contacted to obtain additional information? Our clinic does provide assistance with will writing. We use an application process. Again, as I stated at the beginning, is for persons, low-income persons who we provide the service to, and we assist them. So if an application is submitted and you qualify for our services, we can accept that case and assist with will writing. Can a spouse force the entire portion of their estate to the surviving spouse as opposed to their children? Professor Aubert?
Yes, if he or she has a will and they don't have any forced heirs. But you would have to, again, have a will outlining the fact that you want your spouse to be placed in possession of all your property, both community and separate.
Okay, and this is a very interesting question. Succession sounds very stressful and maybe not worth the effort if the owner didn't have a financial way, I guess, any financial wealth. Is there no way around it? Professor Fasulo, if there's no financial wealth.
Well, according to the Louisiana Civil Code, everything has a value, even if it's just a few cents. A practical matter is this. If you have assets that need to go through a succession, there's a regular succession process and there's a small succession process. But the fact of the matter is this. I guess we need to talk about what do they consider financial wealth. If they have anything, then it has to be passed on to the heirs. Now, if we're talking about personal effects, furniture, clothing, jewelry, things like that, the fact of the matter is technically you're supposed to do a succession and technically it's supposed to go through the succession process. But the fact of the matter is when you start looking at the cost of a succession and the value of the assets that will be transferred, a lot of times the cost of the succession is more expensive than what's going to be passed. And so at that point, quite frankly, it would be more beneficial for the heirs to just agree who's going to get what. But the fact of the matter is, if there's anything, house, car, even if there's a bank account or anything like that has a title to it, I mean, you're going to have to go through the succession process. In East Baton Rouge Parish, just to kind of give you an idea, in East Baton Rouge Parish, the succession, usually just the filing fees, unless you qualify for reduced filing fees, the filing fees can be $1,000. Is it stressful? It all depends on who your co-heirs are, and it all depends on who your attorney is. So that's not an easy answer either. An attorney always hates to say it depends, but it really does depend. It just depends. I don't know if that answers the questions or if that muddied the water more than it was before.
Professor Fasulo, I think probably you also on this question. Doesn't my beneficiaries on my house policy give right to the person that I want? So I guess doesn't the beneficiary, if I have a beneficiary on my house policy, does that give the right to, I guess, that specific beneficiary? Am I directing? I mean, that's what I'm gathering from the question. I don't know.
A house policy, I'm not quite sure what that means. But let me say this in general, and I think we can all kind of agree on this. If you have an insurance policy and there is a named beneficiary, the named beneficiary will get whatever the policy produces. And so that's one of those ads. It's some, I don't know that we touched on this, but any account or any insurance policy that has a named beneficiary passes outside of the will. It follows the named beneficiary form. So that's part of the estate planning. People that have life insurance, retirement accounts, annuities, things like that, make sure those beneficiary forms stay up to date and they say what you want them to say. Because look, I've dealt with successions in the past where somebody left an insurance policy to a trust that had been terminated 10 years prior to the person dying. And so you just have this policy that's supposed to be paid to a trust that's not even there. You can also have policies that are paid to spouses that are now ex-spouses, but they never updated anything. So it can get hairy fast, but in general, if a policy has a named beneficiary, it will be paid to the beneficiary, period.
Okay,
Too
the
generous.
next question is, my siblings and I are having issues with our parents in regards to their estate planning. They're in their mid to late 70s and they refuse to tell us if they refuse to tell us if they have a will, which I don't think they have. What are their final wishes? If they have a life insurance policy, where their documents are stored, etc. My dad has health issues and my mom changes the subject every time we try to talk to her about it. Are there any legal options we as their children can take when it comes to getting power of attorney over both parents? So I'm going to take that question. And I'm just going to take the question from the perspective of the power of attorney. A power of attorney is given, and a power of attorney is given by someone who makes the choice to give it because of some incapacity that they are presently experiencing, may experience in the future. And again, it comes in the form of limited or or however they want to give it. So do your parents have to tell you if they have a will? No. Do your parents have to tell you their final wishes? No. Do they have to tell you where they stored their documents? No. So the answer to all of that is no. If your parents are in bad health, I mean, there's nothing wrong with talking to your parents about it. But if your parents have the capacity and your parents choose to not disclose that information, which they perceive as personal, they can do that. They do not have to tell you anything. It is their property. It is their decision. It is a choice that they have. And if they choose to, they can. Can you obtain power of attorney over persons who do not want to give you power of attorney? No, you can't. As long as they have capacity, they have the ability to give it. If in fact they do not have capacity, and that becomes an issue, then you can get intervention from the court. One thing that I will stress with regard to a power of attorney, in order to give a power of attorney, you must have the capacity to give. You must understand what you're giving. And if you do not understand what you're giving, you lack the capacity and you cannot give power of attorney. But the answer to all of those questions is they don't have to tell you anything. And if they have the capacity, it's a decision that they are making. If they lack the capacity and you go through the court system, that's a whole nother process, an interdiction process, and you would have to go through that process.
And if I could add something, if going through the court system to interdict somebody, that's actually what you're doing is you're actually taking control of their person and all of their affairs. That doesn't give you the right to write a will for them. That doesn't give you the right to do anything like that for them. That just puts you in a position where you can handle things for them. Again, I use the word fiduciary when I was talking about the executor and executrix. If somebody's interdicted, the person that is the person that goes to court to interdict another person, they are in a fiduciary position. They have to act in the best interest of the person they interdicted. And there are serious financial and legal consequences if they don't.
Just to add, a few years ago, I did a seminar, and it was this elderly gentleman, and he had a lot of property up in Cheneyville. And he sat on the front seat when I was doing the seminar, and after it was over, and I asked him, I said, well, how did you like the seminar? He said he loved it fine. I said, well, do you have a joint bank account? He said, nope. I said, well, do you have a power of attorney? He said, nope. Well, do you have a will? He said, no. I said, I thought you liked the seminar. He said, yeah. He said, but I said, well, what are you gonna do? His response was, I'm gonna let him fight over it. And he had a whole bunch of property. He had fields, and he said they don't want it. He said, I'm gonna let them fight over it. I said, really? But he said he's gonna let them fight over it. But yeah, I just want to add.
Well, the
No.
point of this seminar is hopefully we don't let that happen.
Right.
That's what we're trying
Exactly.
to avoid.
Exactly.
That's what we're trying to avoid. Okay, so the next question, is it important to also look at unclaimed property for each state in which a deceased lived and had property when doing a succession? Alicia, this is your question.
My fast answer is yes. Because oftentimes you'll find out that someone died in possession of something, and for whatever reason, oftentimes it's a change in address, or if the person suffered from some type of incapacity prior to their death and wasn't able to keep up with their finances or their records, or sometimes it's property that's deposits that were placed on things, then you will find in those unclaimed property registries that person's name, and you will also find how that the institute that's holding the money can be contacted, or if it's being held by the state, what you need to do to actually collect that and make it a part of their estate.
And Professor Aubert, just hold still. There's another one. If your parents entered into a legal act of donation and donated their house to their 3 daughters, since then, one of the daughters died. She has 2 adult children. How can we get the deceased sister's name removed from the deed?
You cannot. You cannot. The parents entered into an act of donation, and once that donation, act of donation in Louisiana only requires 2 things: the capacity to give and the capacity to accept. So if she accepted the donation, they gave the donation, and she's now the legal owner of 1/3 of whatever that thing is. So her name can't be removed from the deed.
And if I might say, a succession needs to be done,
Yes, and a succession.
and then her 2 adult children split her 1/3. If she has a will, it might go to somebody else. It just depends.
Right. And definitely this is a situation where I would complete a succession, because this is how these generational gaps start. Her name is there, she's deceased, her 2 children are entitled to her 1/3 portion of whatever that, I think you said it was a house. They're entitled to their portion of that 1/3. And if you allow these things to go on ad nauseum, what ends up happening is you have 3 deceased persons whose property has never devolved, and the number of heirs can, grow exponentially with each generation. So this would be one of those situations where it would be practical to open succession and make sure that everybody has an understanding of what they have and the value associated with what they have as well. Oftentimes, people just want to be bought out. So it doesn't necessarily mean you would have to sell the home. They just want to be paid their portion. And then at that instance, they are then relinquishing their right, and they aren't a part of the deed as you move forward.
And I believe that was the last question. So Francis, I'm going to turn it back over to you.
Thank you. I finally figured out how to get a picture on the screen, so I learned something else tonight. And I want to thank all of you so very, very much. The Southern University Law Clinic professors have provided us with an evening that is very, very informative. And I want you to go and let everybody who didn't show up tonight to know that we have this on Facebook, and I believe the session is being recorded. So hopefully they'll get a chance to benefit from being able to go back and look at it. I want to thank you, Professor Lestache, Professor Kane, Professor Aubert, and Professor Fasillo for all of the valuable information that you've given to us tonight. And if we can reciprocate in some kind of way as members of our chapter, we'll be very happy to do that. And we hope that we can call upon you again as we continue with our economic development activities, and when we need something that you can provide for us to provide to the community. So thank you very much, and we will be in touch. I'm not sure if our president is still on the line, but I have one announcement that I need to make from the Economic Development Committee, and that is we are preparing for our another part of our series, and that's Kid Entrepreneurs and Food Truck Showcase, which will take place on Sunday, June the 5th of 2022. And we are still in the process of looking for kid entrepreneurs. If you know any, we ask that you get in touch with the Economic Development Committee. And if you know minority food truck owners that we can use and place in the showcase, we would appreciate having that information also. If I think the president may not still be with us, and if she's not, I'd like to use this opportunity to say thank you for joining us and for participating in our continuing offerings to the community for programs such as this. And we look forward to the next time we get a chance to meet like this. Baton Rouge Sigma is deeply appreciate your support and your continuing interest in our ongoing programs in this virtual community. If there are no other announcements.
Is present.
Oh, she is present. Thank you very much. Then I'll turn it over to our president, Shy Joseph Franklin.
Good evening, everyone. It has been such a great evening and a wealth of information. And we are, as Sarah Francis has stated, very grateful to the Southern University Law Center Clinic for being here with us this evening. And we do look forward to any future partnership as well as any other activities to come in the future. And just as a plug for Baton Rouge Sigma, we do have for our young men ages 11 to 18, we have a program coming up this Saturday called Embody, and it will be a wealth of information for our young men. So look to our website, our Facebook page for being able to be a part of this. So we hope that you've definitely gained a lot of information this evening to do what you need to do to have your business in order. Thank you so much this evening, wherever you are, and we look forward to being with you again. Have a great evening, everyone.
Thank you. Appreciate it.
Thank you.
Thank you. Good evening. Bye-bye.